What if my petitioner naturalizes? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, Missouri and San Diego, California. We had a couple of questions asked last week in our Immigrant Home Facebook group. By the way, if you're not a member, you should think about joining. It's free, and we share a lot of great immigration information in there, and that's where I get a lot of my ideas for questions. So if you have questions, you can leave them in there, and sometimes I'll shoot a video. But we had a lot of questions last week about what happens if I have a pending either adjustment case or a immigrant visa case, usually an immigrant visa case, and my petitioner naturalizes. And so that is that the case was filed on behalf of a lawful permanent resident who wanted to sponsor their spouse or their underage child or their overage child, their child over the age of 21. And that's really where we see it the most, is where a lawful permanent resident is sponsoring their child who's over the age of 21 to come to the United States and to get an immigrant visa. And that process can take years depending on the country of origin and depending on the priority date. That can take a long time, and sometimes the petitioner will become a U.S. citizen. And because of limits and caps on the categories of people that come to the United States, there are different delays, different lengths of time by which someone can come to the United States. In other words, there's a backlog. And the strange thing is that the line for the adult children of U.S. citizens is longer than the adult children of lawful permanent residents. That's just because there have been more people apply as citizens for their adult children to come to the United States. And so when that happens, when the green card holder becomes a citizen, when the petitioner, the person doing the sponsoring, becomes a citizen, in theory, they lose that priority date. Their case would go slower because they're supposed to, the time that they were coming as a green card holder, when they were sponsoring as a green card holder, now that they're becoming a U.S. citizen, that line is longer. And so the question is there a way to keep that priority date? And yes, there is. You can ask the National Visa Center to continue to treat your case as the adult child of a green card holder instead of as a citizen. In other words, your petitioner can take advantage of becoming a citizen, but you can also stay in the line that you were in before. You don't have to go back to that other line. You don't have to start over for sure, and you don't even have to have your case categorized as the adult child of a citizen. Now, in other situations, it's a good thing when the petitioner becomes a U.S. citizen. If a green card holder has sponsored their spouse, and if we're in a time where there are a backlog of visas available for the spouses of green card holders, and the green card holder becomes a citizen, that's really good. You can notify wherever the case is, at USCIS or the National Visa Center or at the embassy, that the petitioner has become a U.S. citizen, because they're going to have a greater priority. And even like now, where things are the visa numbers for green card holding spouses is current, you still want to notify them that you are now a U.S. citizen. They'll treat your case better. Your case will go faster. So lots to think about when the petitioner is thinking about becoming a U.S. citizen. The final thing is they could knock out the application if it's like a follow to join application based on the person being awarded green card status. That's a little bit trickier. But in all these scenarios, if you are thinking about, if you have a pending visa application, and if you're thinking about naturalizing as a petitioner, you probably need to talk to an immigration lawyer to make sure that you're not doing anything to screw up your case, or how to take advantage of the fact that you've become a citizen so that you can get greater priority and greater attention paid to your case. Hope this all makes sense. I was a little jumbled up today. It's a hard thing to explain without visuals. Like usually I'd like to have, here's the line for the adult children of citizens, here's the line for the adult children of lawful permanent residents. This line is actually shorter than this line, and when you move from one to the other, you can, in theory, you'd lose time. You'd lose a couple years of time, but there's a way that if you notify the National Visa Center correctly that you want to be treated as the adult child of a green card holder, even though mom or dad became a U.S. citizen, you can still do that. It's just a little bit tricky to pull off. If you have questions about this, give us a call, 314-961-8200. You can email us at info@hackinglawpractice.com. Be sure to join us in our Facebook group. It's called Immigrant Home. We'd love to see you in there. We also have our YouTube channel that you should subscribe to so that you get updates whenever we make videos like this one. Don't forget, every Tuesday and Thursday, usually around noon Central Time, you'll find us in our Facebook group, on our YouTube channel, answering as many of your immigration-related questions as we can. Thanks a lot. Have a great day.